Convention on the Non-Applicability of Statutory Limitations to War Crimes and Crimes Against Humanity. Done at New York on the 26th of November 1968, entry into force, the 11th of November 1970. Preamble. The states parties to the present convention. Recalling resolutions of the General Assembly of the United Nations 3I, of the 13th of February 1946 and 172, of the 31st of October 1947 on the extradition and punishment of war criminals, Resolution 95. I, of the 11th of December 1946 affirming the principles of international law recognized by the Charter of the International Military Tribunal, UNCLOS, and the judgment of the Tribunal, and Resolutions 2184, 21, of the 12th of December 1966 and 2202, 21, of the 16th of December 1966 which expressly condemned as crimes against humanity the violation of the economic and political rights of the indigenous population on the one hand and the policies of apartheid on the other. Recalling resolutions of the Economic and Social Council of the United Nations 1074d. 39, of the 28th of July 1965 and 1158, XLI, of the 5th of August 1966 on the punishment of war criminals and of persons who have committed crimes against humanity. Noting that none of the solemn declarations, instruments or conventions relating to the prosecution and punishment of war crimes and crimes against humanity made provision for a period of limitation. Considering that war crimes and crimes against humanity are among the gravest crimes in international law. Convinced that the effective punishment of war crimes and crimes against humanity is an important element in the prevention of such crimes, the protection of human rights and fundamental freedoms, the encouragement of confidence, the furtherance of cooperation among peoples and the promotion of international peace and security. Noting that the application to war crimes and crimes against humanity of the rules of municipal law relating to the period of limitation for ordinary crimes is a matter of serious concern to world public opinion, since it prevents the prosecution and punishment of persons responsible for those crimes. Recognizing that it is necessary and timely to affirm in international law, through this convention, the principle that there is no period of limitation for war crimes and crimes against humanity, and to secure its universal application, have agreed as follows. Article 1. No statutory limitation shall apply to the following crimes, irrespective of the date of their commission. F. Degrees, war crimes as they are defined in the Charter of the International Military Tribunal, UNCLOS, of the 8th of August 1945 and confirmed by Resolutions 3I, of the 13th of February 1946 and 95I, of the 11th of December 1946 of the General Assembly of the United Nations, particularly the grave breaches enumerated in the Geneva Conventions of the 12th of August 1949 for the protection of war victims. B. Crimes against humanity whether committed in time of war or in time of peace as they are defined in the Charter of the International Military Tribunal, UNCLOS, of the 8th of August 1945 and confirmed by Resolutions 3I, of the 13th of February 1946 and 95I, of the 11th of December 1946 of the General Assembly of the United Nations. Eviction by armed attack or occupation and inhuman acts resulting from the policy of apartheid, and the crime of genocide as defined in the 1948 Convention on the Prevention and Punishment of the Crime of Genocide, even if such acts do not constitute a violation of the domestic law of the country in which they were committed. Article 2. If any of the crimes mentioned in Article I is committed, the provisions of this convention shall apply to representatives of the state authority and private individuals who, as principals or accomplices, participate in or who directly incite others to the commission of any of those crimes, or who conspire to commit them, irrespective of the degree of completion, and to representatives of the state authority who tolerate their commission. Article 3. The states parties to the present convention undertake to adopt all necessary domestic measures, legislative or otherwise, with a view to making possible the extradition in accordance with international law, of the persons referred to in Article 2 of this convention. Article 4. The states parties to the present convention undertake to adopt, in accordance with their respective constitutional processes, any legislative or other measures necessary to ensure that statutory or other limitations shall not apply to the prosecution and punishment of the crimes referred to in Articles I and II of this convention, and that, where they exist, such limitations shall be abolished. Article 5. This convention shall, until the 31st of December 1969, be open for signature by any state member of the United Nations or member of any of its specialized agencies or of the International Atomic Energy Agency, by any state party to the statute of the International Court of Justice, and by any other state which has been invited by the General Assembly of the United Nations to become a party to this convention. Article 6. This convention is subject to ratification. Instruments of ratification shall be deposited with the Secretary-General of the United Nations. Article 7. This convention shall be open to accession by any state referred to in Article V. Instruments of accession shall be deposited with the Secretary-General of the United Nations. Article 8. 1. This convention shall enter into force on the 90th day after the date of the deposit with the Secretary-General of the United Nations of the 10th instrument of ratification or accession. 2. For each state ratifying this convention or acceding to it after the deposit of the 10th instrument of ratification or accession, the convention shall enter into force on the 90th day after the date of the deposit of its own instrument of ratification or accession. Article 9. 1. After the expiry of a period of 10 years from the date on which this convention enters into force, a request for the revision of the convention may be made at any time by any contracting party by means of a notification in writing addressed to the Secretary-General of the United Nations. 2. The General Assembly of the United Nations shall decide upon the steps, if any, to be taken in respect of such a request. Article 10. 1. This convention shall be deposited with the Secretary-General of the United Nations. 2. The Secretary-General of the United Nations shall transmit certified copies of this convention to all states referred to in Article V. 3. The Secretary-General of the United Nations shall inform all states referred to in Article V of the following particulars: degrees, signatures of this convention, and instruments of ratification and accession deposited under Articles 5, 6 and 7, b. The date of entry into force of this convention in accordance with Article 8, c. Communications received under Article 9. Article 11. This convention, of which the Chinese, English, French, Russian and Spanish texts are equally authentic, shall bear the date of the 26th of November 1968. In witness whereof the undersigned, being duly authorized for that purpose, have signed this convention.